My name is Lisa Chen, and this is our teamwork with my partners, Yingxuan Qiu and Samuel Wong. We're going to talk about one Chief Justice and two Supreme Court cases.
Let's talk about Harlan F. He was born in Chesterfield, New Hampshire, on October 11, 1872. He was a semester of Newburyport High School. He attended Amherst College and the Columbia Law School, where his intellect so expressed his teachers. In 1924, President Calvin chose Stone as his Attorney General. The following year, college named him Associate Justice of the Supreme Court. And in 1944, he became the Chief Justice. He opposed the ruling in Minersville School District vs. Cobbington. Hirabayashi vs. United States, and Corey Matisu vs. United States. Harlan Stone died on April 22, 1946. In the picture were Stone and his wife Agnes. Also, Harlan Stone had two sons called Marshall and Lawson.
Next is the first Supreme Court case Railway. The case ruled unconstitutional a state law that banned abortions except to save the life of the mother. The court ruled that the state was forbidden from outlawing and regulating any aspect of the abortion performed during the first trimester of the pregnancy, could only enact abortion regulations responsibly related to maternal health in the second and third trimesters, and could enact abortion laws protecting the life of the fetus only in the third trimester. This case originated in the Dallas country. This goes to the Supreme Court because this is a case related to the federal restrictive criminal abortion laws. The court held that a woman's right to abortion fell within the right to privacy protected by the 14th Amendment. The decision gave a woman a right to abortion during the interior of the pregnancy and different levels of the state interest for regulation abortion in the second and third trimesters. Norma McCorvey was a Texas resident who sought to obtain an abortion. However, Texas law prohibited abortions except to save the pregnant mother's life. She was pregnant when she became the lead plaintiff in the case. McCorvey gave up the baby for adoption. She has since come forward and changed sides on the abortion dated. In 1997, McCorvey started a pro-life outreach organization that was dissolved in 2008. The second person involved was Henry Wade. He was the district attorney of Dallas County from 1951 to 1987. Norma McCorvey sued him because he enforced a law that prohibited abortion except to save a woman's life.
The second case is Whitney, California, happened in 1927. Caroline Anita Whitney, a member of a distinguished California family, was convicted under the 1919 California Criminal Syndicalism Act for allegedly helping to establish the Communist Labor Party of America, a group charged by the state with teaching the violent overthrow of government. Whitney denied that it had been the intention of her or other organizers for the party to become an instrument of violence. The California Criminal Syndicalism Act prohibited any person to knowingly become a member of any organization that advocates criminal syndicalism. The defendant, Anita Whitney, was affiliated with an organization that adopted a left-wing manifesto, and therefore convicted under the act.
Louis Brandeis, 1856 to 1941, is well known for his support of an individual's right to privacy and free speech. His concurring opinion in Whitney v. California. It was a United States Supreme Court decision upholding the conviction of an individual who had engaged in speech that raised a threat to society.
The other people involved in this case are William Taft and Associate Justice. The case was argued on October 6, 1925, and it was re-argued on March 18, 1926. It finally decided on May 16, 1927. The case was originated in California. Those who own our independence believe that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberate forces should prevail over the arbitrary. This case finally convicted under clear and present danger, and Whitney attended a communist convention where violence was advocated as a means to overthrow a government. It presented for ruling in Dennis v. U.S. 1951.